Today we're looking at civil rights. Remember, civil liberties are the guaranteed protections from our government, which were written into the Constitution after ratification of the Bill of Rights. Civil liberties are how the anti-federalists like Brutus got their way in protecting their personal and state freedoms from the new powerful federal government. Civil rights, then, are the movements to claim and protect the rights that are promised to all residents of the United States when those rights are challenged or denied. Anything that has to do with race, religion, ethnicity, sexuality, or gender are fair game for a civil rights movement. Before we begin, look out for these questions. What are the differences between civil liberties and civil rights? What constitutes a civil rights complaint? What are the levels of scrutiny, and how do they apply in a court of law? Can you identify any political trends and predict where we're headed? Discrimination is the act of withholding guaranteed rights due to race, religion, ethnicity, gender, sexuality, etc. Remember the civil liberties mini unit? Your civil liberties are the same as everyone else's in the orchard. We all have those guaranteed rights in order to have a healthy orchard. But what happens when those rights are not promised to all? When people are discriminated against, the overall health of the orchard declines. The founding principles of liberty, democracy, republicanism, and freedom are not able to stand when we no longer have a pluralist model of governing. Remember, with pluralist democracies, we need plural or participation of the many. We need representation by multiple interests to reach Locke's, Rousseau's, and Jefferson's ideal democratic model. Otherwise, Brutus's fears of tyranny of the masses in the hands of the few prevails. Enter civil rights movements. When thinking about civil rights movements, we need to change our thinking about these issues as only being there to protect racial groups. In fact, it goes much deeper to protect anyone who raises a claim as a group of people who need access to facilities, opportunities, or services that are available to other groups. This leads to the definition of something called the protected class status. Simply, protected classes are anyone who needs protection from discrimination, which includes minority groups, women, groups over the age of 40, and disabled persons. What do they all have in common? In order to pursue a civil rights action in court, we must classify the bias under various tests of review. First is strict scrutiny. Strict scrutiny says that racial classifications are inherently suspect and are upheld only if there is a compelling public interest. Therefore, we may only, as a government, demonstrate racial bias if it's for the greater good. Look at this as a bit of a double negative. When we say it is for the greater good for one group to be discriminated due to race, when will that ever happen? Let's think about Shaw v. Reno. In Shaw v. Reno, the court decided that allowing the creation of a race-based district was ultimately against the compelling public interest. See that pink little sliver of a district in the middle? District 12? It was created strategically to allow for a black district in North Carolina. However, the court ruled that ultimately this was degrading to the African American population, in stating, the justices said that classifications of citizens predominantly on the basis of race are undesirable in a free society and conflict with the American political values of equality. The majority said that any redistricting plan that includes people in one district who are geographically disparate and share little in common with one another but their skin color bears a strong resemblance to racial segregation. Therefore, in this case, strict scrutiny applied and gerrymandering a district did not uphold the democratic principles of America. Next is mid-level review, which is similar to strict scrutiny of race, but it's implied for gender qualifications. Enter Craig v. Boren. Craig, the appellate male between the age of 19 and 21, was denied being sold beer at his local liquor store. Why? Because the 1976 Oklahoma law forbid males under the age of 21 from purchasing beer, while women, on the other hand, were allowed to purchase as much beer as they wanted beginning at age 18. According to Craig, this was a deliberate affront to the 14th Amendment Equal Protection Clause. Therefore, women being treated unequal to men in the purchasing of alcohol was unfair and did not uphold a legislative purpose. And finally, the rational basis test, where any other classification must be reasonable. Good job, lawyers, whatever that means. For something to undergo a rational basis test, it must first be assumed that the law was written with good intentions. But showing that intentions are not valid is the real trick. How do you even demonstrate what lawmakers were thinking when a law was initially written. And how do you demonstrate emotional intent? It must go against the democratic safety of the United States. Not selling alcohol to 14-year-olds may be age discrimination, but the prurient interest of society says otherwise. So what fits the rational basis then? Meet Edith Windsor and Thea Spire. Their marriage was recognized in the state of New York in 2008, but Spire sadly passed away in 2009, leaving her entire estate to Windsor. Windsor wanted to claim the federal tax exemption on the estate as are promised by married couples, but she was denied due to her marriage being that of same sex. When the case was appealed to the Supreme Court, Justice Kennedy wrote the decision that the law barring access to the tax exemption did not uphold a racial basis. What purpose did the law serve, being that it was aimed at sexuality? He writes, "The federal statute is invalid, for no legitimate purpose overcomes the purpose and effect to disparage and to injure those whom the state, by its marriage laws, sought to protect in personhood and in dignity." So are there times when the United States has allowed for legal discrimination? Yeah. Our Constitution allows for the suspension of habeas corpus during times of war and rebellion. When the United States set up internment camps for Japanese Americans during World War II, it was considered constitutional, as the national security interest outweighed civil rights concerns. While many presidents have apologized to Japanese descendants, it is still considered a precedent for restricting habeas corpus in times of war. While Korematsu provides a legal precedent of civil rights being overturned by the Supreme Court, the level of scrutiny still applies throughout the civil rights movement of the 1960s and 70s. Mostly, these legal challenges advanced most significantly with the Brown v. Board of Education cases. But first, we must begin with the case of Plessy v. Ferguson. In 1896, Homer Plessy was denied access to the white train car and claimed this went against his 14th Amendment rights of equal protection of the laws. However, the court defied the Equal Protection Clause, redefining it for the next 60 years, establishing separate but equal as a new platform to reconstruct the United States after the Civil War. So how can the National Association for the Advancement of Colored People, or the NAACP, strike down Plessy? Well, they start with demonstrating the obvious inequities over time. This isn't easy, though. First, in the case of Cumming versus Richmond, Virginia in 1899, the court refused to issue an injunction preventing a school board from suspending tax money on a white high school when the same school board voted to close down a black high school for financial reasons. Or in Gong Lum v. Rice, 1927, the court upheld a school's decision to bar a person of Chinese descent from a white school. Enter the case Murray v. Maryland in 1936. The University of Maryland School of Law was denying African Americans to attend the school purely on the basis of race. Thurgood Marshall, future SCOTUS judge, argued Murray was just as qualified as white applicants to attend, and Murray was only rejected due to his race. Next, he argued that since the black law schools were nowhere near the same academic caliber as the university's law school, the university was violating the principle of separate but equal. The same strategy is effective in cases such as Missouri Gaines versus Canada and Sweat v. Painter, where higher education facilities proved it was impossible to uphold separate but equal. Now finally, enter Brown v. Board of Education in 1954. It's a series of two consolidated cases which found public school education could not be separate but equal, and instead created the famous declaration which reversed Plessy v. Ferguson: separate is inherently unequal. Therefore, schools needed to be integrated to provide for the equal economic opportunities for citizens. Did you notice that I didn't use the 14th Amendment Equal Protection Clause just there? Yeah, Brown v. Board decided that public education was not the intent of the 14th Amendment's Equal Protection Clause, and instead found that Plessy's law of separation was ultimately detrimental and created a sense of inferiority for African American students. Because there was a lack of action and no directives legislated from the bench, a secondary order had to be created which stated that the public schools in Topeka, Kansas needed to be desegregated with all deliberate speed. The Brown v. Board of Ed decision in 1954 takes over 20 years to enact. In Swan v. Charlotte, Mecklenburg, the court was asked the question, were federal courts constitutionally authorized to oversee and produce remedies for state-imposed segregation? To which it ultimately answered, yeah. Schools and districts must adhere to ratios and quotas to demonstrate a real effort to desegregate their school systems. The equal education movement is the most profound legal attack at segregation, which upholds the legal and moral merits of the civil rights movement of the 1960s and 70s. While Dr. King's movement was centered around peaceful protest, protesters were most often met with violence and arrested. For example, in the Children's March of Birmingham, peaceful protesters were attacked with fire hoses and police dogs, later to be arrested for defying public orders to disassemble. Dr. King himself was arrested a total of 7 times for multiple offenses such as loitering, perjury, and sit-ins. After his arrest in Montgomery, Dr. King wrote the famous Letter from a Birmingham Jail, where he wrote, "Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly." He further states, "We know through painful experience that freedom is never voluntarily given by the oppressor, and it must be demanded by the oppressed," which goes straight back to the Declaration of Independence and Thomas Jefferson. In King's ultimate success, the following year was the Civil Rights Act of 1964, which created the levels of strict scrutiny which prohibited discrimination in public places, forbade discrimination in employment, and authorized suits and review boards by the Justice Department. Of course, that legislation wasn't going to go unchallenged. In the heart of Atlanta Motel in 1964, a white hotel owner refused to rent rooms to African Americans. He claimed the Civil Rights Act was restricting his freedoms as a private property owner, and the U.S. government could not tell him how to run a business. But according to the Interstate Commerce Clause of the U.S. Constitution, the hotel being located on a main highway connecting states and other cities, it was essential to the economy and therefore could be regulated. Again, the 14th Amendment Equal Protection Clause was not used as the primary justification. The same year as the Heart of Atlanta decision and the Civil Rights Act of 1964, the 24th Amendment passed, which made paying an extra tax to vote illegal. Finally, in collaboration with the 24th Amendment, the Voting Rights Act of 1965 allowed for federal marshals to be sent to the South to protect the voting rights of African American citizens. Since 1965, the Voting Rights Act has become more limited. Over the last 60 years since the Civil Rights Act and Voting Rights Act, various acts of legislation have been passed and revised to desegregate schools and workplaces. Affirmative action was one of those tools, which continues to be reviewed by the courts on behalf of strict scrutiny. So, what happens when the offense is not about race? And are there times that we allow for gender bias? Think about the draft system. Sexual harassment is considered a civil rights complaint of mid-level review. This is divided into 2 classifications of quid pro quo and hostile environment or workplace. Quid pro quo is asking for sexual favors which are rewarded with workplace advancement. Mid-level review cases also protect our LGBTQ+ community. Here in the state of Colorado, Governor Roy Romer found himself in the Supreme Court when Colorado voters adopted a state amendment, making it illegal to protect people due to their sexual orientation. Or, in the state of Texas in 2003, laws could no longer forbid sexual encounters between same-sex couples. Ultimately, it was Obergefell v. Hodges that used the 14th Amendment Equal Protection Clause to protect same-sex marriage throughout the United States, and due to national supremacy, no state could legislate otherwise. Finally, the Civil Rights Act of 1964 protects minorities, Title IX protects women, and the American with Disabilities Act of 1990 protects our disabled population. Anyone with an IEP or 504 is further protected by this law in our schools under the IDEA Act, or Individuals with Disabilities Education Act. Going against these protections would be considered a civil action lawsuit. In all of these cases, we must meet our disabled with a reasonable accommodation for equal access to facilities. In review, take a second and see if you can answer the following questions using the evidence from the lecture. First, what is the difference between civil liberties and civil rights? Can you list any specific examples? Second, what would constitute a civil rights complaint, and how would we define the applicable level of scrutiny? Finally, what do you think is going to be the next civil rights challenge to the United States?